And welcome to another episode of All Things Conflict with me, your host, Maria Arpa. And before I tell you what's in store today, I'd like to share with you some details about my flagship dialogue roadmap training. As you know, I've been doing this work for 30 years, prison schools, communities, on the streets, in workplaces, with businesses, internationally, locally. And I've learnt a thing or two. And for the last 7 years, I've condensed that into 20 days of intensive training supported over a year with a diverse group of people from all walks of life. And if you're interested in mastering the skills of mediation, conflict resolution, restorative justice, and even just navigating the difficult conversations of life, then get in touch with me at mariaarpa.com and let's talk about whether you might be suitable for my 2027 cohort. Thank you. So in today's episode, I'm covering a really important topic. I'm covering a topic of a man called Jeremy Bamber, who's been in prison for 41 years and has protested his innocence. I'm welcoming onto the show Phillip Walker, who is part of the Jeremy Bamber Innocence campaign. And we will also be hearing from Michael Watkins, who was a journalist originally wanting to find evidence to support the conviction, but who subsequently changed his mind. Let's jump in. Phillip, welcome to All Things Conflict, and thank you for agreeing to come on the show. We met not that long ago, and I think you were interested in the episode we did with Lucy Letby's lawyer, and I was certainly interested in miscarriages of justice and when people are wrongfully imprisoned and the potential for innocence and all of those things. And you're actually an innocence campaigner for Jeremy Bamber.
That's right.
So maybe you could introduce yourself.
Yes, I'm Phillip Walker, as you said. I'm a member of the Jeremy Bamber Innocence campaign. And there's a tenuous connection we have to the Letby case, is that both of these cases, which are very important potential miscarriages of justice in the UK, were both covered in extensive articles in the New Yorker. And the journalist who worked on Jeremy's case, Heidi Blake, was a very well-known UK investigative journalist. She used to be at the Sunday Times and worked on the FIFA files, which eventually led to Sepp Blatter losing his job at FIFA. So having somebody of her high profile looking at our case was extremely helpful. And she came up with some really compelling further evidence of Jeremy's innocence. So at the moment, our campaign has got real momentum, and it's great to have the opportunity to come on and talk to you about it.
Thank you. Yeah. Well, I mean, we have to have people supporting all parts of the justice or injustice system. So it's great work that you're doing. But maybe you could, first of all, just take us back to what the case actually is. Because as I understand it, Jeremy has been in prison for 41 years, potentially for something that he hasn't done.
That's right. Well, the tragedy itself occurred in 1985, on the 7th of August 1985, when 5 members of the same family, Bamber family, and those were Neville Bamber, the patriarch of the family, his wife June, their daughter Sheila, and Sheila's 2 twin sons, Nicholas and Daniel, were all found dead at a property called White House Farm near Tolson Darcy in Essex. Now, initially, the police, in our opinion, quite correctly, concluded that this was a murder-suicide case, that Sheila, who had a long history of psychiatric problems, she, for whatever reason, had had a psychotic episode. She shot the other four members of the family and then tragically turned the gun on herself. And that was the initial narrative that held for about a month after the actual incident. But because of a toxic mix of various police officers who, for whatever reason, had taken against Jeremy, some of his extended family, who, as it turned out, had a very strong financial interest in ensuring that he didn't inherit any of the Bamber estate, which eventually went to them, and also because of the input from his girlfriend, who he split up with shortly after the tragedy, Julie Mugford. Those three parties came together and helped the police put together the case that eventually, on a 10-2 majority verdict, convicted Jeremy in 1986. And he was first on remand in September 85. So as you pointed out, he's now been in prison for 41 years. And during the whole of that time, he has protested his innocence. And our view and all the evidence shows that the police were correct in their initial assessment that it was a murder-suicide by shooting.
So what's interesting about that, because, obviously it's good to give people context, is had he agreed that he'd done the murder and pleaded guilty, or even been found guilty and said, yes, I did it, he would have been out of prison by now. The most likely thing is that he would have got a life sentence of 30 years. He would have engaged in a sentence plan. He would have worked his way through the system. I mean, assuming that he was cooperative as a prisoner, and he would have probably been released after around 15 years. But because when a person says, actually, I didn't do this and I'm not going to own up to something that I didn't do, the system doesn't know what to do with them, because they can't engage in a sentence plan where they take responsibility and show remorse.
That's right. You're quite correct that initially he was given a life sentence, with the judge recommending a minimum of 25 years. And had he, as you pointed out, admitted his guilt during the first few years of his imprisonment, that clearly would have gone strongly in his favour when he eventually came up for parole. However, that scenario was slightly overtaken by the fact that about 6 or 7 years later, he was then, in secret, given a whole life tariff by the Home Secretary. So, in fact, now he is a whole life tariff prisoner, so has no prospects of release. So yes, you're quite right. If initially he had held his hands up for what supposedly have committed this crime, it would have gone very much in his favour. But because he didn't do it, clearly he wasn't prepared to do that.
Yes, and I've met other people, with other kinds of convictions where the fact that they're saying, I did not do this and I can't just agree, has actually worked in their detriment.
Yes, the most recent one, an example is Andrew Malkinson, who also, quite rightly, refused to own up to something he hadn't done. So yes, it's a very odd quirk of the criminal justice system.
Yeah, and I think that Mark MacDonald, who is Lucy Letby's barrister, I think he said that actually getting an appeal and working through those things is actually easier in the United States than it is in the UK, apparently.
Well, yes, I mean, it is such an involved process, mainly because of the role of the CCRC, which has in practice differed hugely from the intention of Parliament when it was set up. The House of Commons and House of Lords agreed that a body should be set up to investigate miscarriage of justice after the well-known cases such as the burning of Sitsley Guildford Court. And their view was that an independent body without fear or favour should look at all the evidence in a case and come to an independent conclusion. However, that's not the way it's worked out in practice, for a number of reasons, partly because the CCRC employ a large number of ex-police officers who I think instinctively do not like to criticise their former colleagues. So it is a massive roadblock on the road to an appeal, and then if you're lucky, an exoneration, to have to go through the CCRC. We've been engaging with them now on this latest round of submissions for over 5 years. Jeremy put in 10 grounds in March 2021. They provisionally rejected 4 of them in June of last year, and they're still looking at the remaining 6. So if they keep up this rate of progress, it's going to be another, the rest of the decade before they actually manage to come to a firm final conclusion. But we have gone back to them with a lot of the new evidence which hopefully we'll come on to discuss, and said that their provisional reasoning was flawed. And we hope that the new regime under Vera Baird, who shows a much more acute sense of how miscarriages of justice happen, will engage with that and review their decision.
Yeah, thank you. And again, just for context, before we really get into, Jeremy's specific case, I've spent a fair amount of time in prisons representing the charity that I founded. And, 95%, if not more, of people accept that they've committed a crime. They just want to do their sentence, as quietly and as quickly as possible, and come out perhaps a little better off as a human being than when they went in, if that's at all possible. So, when people protest their innocence as as vehemently as Jeremy has done, and others, it isn't like you've got thousands of people and everyone's trying to protest their innocence. It isn't like that, so it's a small number of people, and it's worth taking seriously.
Yes, it is. Well, as well as the incentive you mentioned earlier on about improving your chances of parole, which is clearly a very strong incentive. Just the amount of effort that you have to put in to maintain a campaign of innocence is huge. So, as you point out, there are very, very few cases where people have protested their innocence over a long period who have turned out to be guilty. In fact, I only think of one. That there have been a lot of people over the years who have protested their innocence. So yes, everything is stacked against you if you're claiming innocence.
Yeah, thank you. So let's really get into Jeremy's case, and I guess I suppose I'm interested in your own motivations. What's your motivations for this, and then secondly, some of the real nitty gritty evidence that's come up.
Well, I've got no skill set that's directly relevant to such an innocence campaign. My background has been finance, so I've just followed the case over the years just as a member of the public. But I have a couple of similarities in my background to Jeremy, in that I was adopted around the same time through the Church of England's Children's Society as he was. So I suppose that's given me a slight extra connection. But it's just been a matter of reading up about the case and concluding that the prosecution case is just completely flawed in every respect. And once I come to that conclusion, I just wrote to Jeremy and said, I've got a bit of extra spare time now. If there's anything I can do to help, let me know. And it just went from there.
So you didn't know him. I mean, you just had a tenuous connection in a similarity of background, but you didn't know him. You just followed the case, and I guess it's that, deep human need for fairness.
Yes, exactly. I was always, as most people are, brought up to respect the criminal justice system. That in this country we gave everyone a fair hearing, and to find out that wasn't always the case came as something of a shock, I have to say. And one of the key things I did in the reading that I undertook was to read Caroline Lee's so-called definitive book on the case, which has received a lot of publicity and has been widely read. And in fact, it was her book actually that really got me thinking about some of the things she set out in her book just don't add up. So that was what prompted me to do some further research.
So then that's taken you down the rabbit hole. So
And it's a very deep rabbit hole, and
so I'd love to hear some of the new evidence or uncoverings or things that don't add up that that people could consider.
well, let's look at the things the New Yorker came up with in their article, and subsequently in their podcast. This is not an exclusive list of all the exculpatory evidence. There's much more, but these are things that are quite easy to understand and that will shock people. The primary thing that came out of Heidi Blake's investigation was when she spoke to a police officer called Nick Milbank, who had been manning the 999 lines at Essex Police Headquarters that night. And we had found some years ago an action report from the subsequent investigation that was done before Jeremy's 2002 appeal by the Met Police. And in that investigation, they referred to an action about a 999 call that was received from White House Farm, which is where the tragedy took place, at 6:09 in the morning. Now, when this was challenged by the defence before the 2002 appeal, Essex Police told them that, this report was just a misunderstanding and that there hadn't been a 999 call, they'd just been monitoring the open line into the house. So the defence accepted that and didn't raise the point of appeal. But Heidi Blake tracked down Nick Milbank and spoke to him and asked him, did you take a call at 6:09 in the morning from White House Farm? And much to everyone's amazement, he said, oh, yeah, of course I did. Yeah. And then went on to describe the circumstances in which he took that call, what he heard on the call. And even more worryingly, he then said that the statement that Essex Police had produced in 2002, which said that all this was just a misunderstanding, and which supposedly had been signed by Nick Milbank, the actual statement was typed and not signed by hand. It was just a typed up signature. He said, well, I've never seen this statement at all. This has nothing to do with me. It's not the type of English I use. I never sign my name, Nicholas Milbank. I always use my initials, NR Milbank. So basically, he totally disowned this statement that had previously dismissed this whole issue. Now, if there was a call, as Nick Milbank said there was, at 6:09 from within White House Farm, that clearly means somebody was alive in the farm at that time. Jeremy at that point was standing outside surrounded by literally dozens of police officers. So there is no way that he could have committed the shooting and somebody was still alive inside the house just after 6:00 in the morning. So that was the first piece of evidence that Heidi came up with. But that had an extraordinary effect in terms of when that was put to the CCRC, rather than the CCRC themselves going to talk to Nick Milbank and saying, well, obviously what you said is very interesting. Is it true? Could we check it? Are you sure about this? They handed the whole matter over to Essex Police, which is really jaw-droppingly extraordinary. So they got Essex Police to mark their own homework, and they hot-footed it round to Nick Milbank and got him to sign a statement saying, oh, well, I didn't know I was talking to a journalist, and just trying to muddy the waters, basically. Although he never actually denied saying anything that was quoted in the article or the podcast, but it tried to sort of hint that he'd been misled into saying what he said. So that had a huge impact when that came out in the New Yorker article about 18 months ago. And the whole issue is still at the CCRC. And they initially dismissed it, but on grounds that were, to be honest, quite surreal. So we've gone back to them and said, you really have to take this more seriously. You have to investigate more. And we are hoping that that's what they're doing at the moment. So that was the first thing that Heidi Blake came up with.
So this bit about the 999 call and everything, this is a really good moment to hear some of Michael's pre-recorded, because he couldn't be with us today. It's a really good moment where we could hear something from Michael about his experience, because not only has he read this evidence, but he actually was a BT operator at the time. So let's just tune into a bit of that.
Well, basically, my background, career-wise, over 4 decades, has been as a broadcast journalist, ex-BBC, ex-Sky. I would like to think that I can tell fact from fiction, and that it's woven into my DNA that I double-check my facts. A number of years ago, I started looking into Jeremy's case, fully expecting that the facts that I would independently unearth, albeit with the assistance of the Innocence campaign, would actually confirm the conviction. But what I found, to my horror, in fact, was that the opposite was the case. Everything that I was able to unearth pointed towards obvious innocence. And I don't say that lightly. I speak entirely as an independent person when I make that assertion. The other job that I did that I think is highly relevant to the research, which has caused me to conclude that Jeremy did not commit this terrible crime, is my experience from the 1980s as a 100 and, most importantly, a 999 telephone exchange operator. And this, I've been able to apply that industry knowledge to the documentation which exists. And I could say, as a matter of certainty, if only within my own mind, but that counts for something, that there was a 999 call at 6:09 a.m. on the morning of the tragedies from within White House Farm. And what that means is that Jeremy cannot possibly have committed this crime. It's just impossible. I think the thing that gets to me about this case, above most other factors, is the fact that I know how a telephone exchange works. In the 1980s, I was an operator for BT, taking emergency 999 and 100 operator calls. And the police have made certain assertions in relation to the fact that, despite the availability of documentation pointing to a 999 call having happened, that in fact something else happened instead. I've been able to apply my industry expertise and the knowledge that I know is easily provable to show that the explanation offered by the police is complete procedural, technical nonsense. I'll park that for a moment, if I may. The reason that the 999 call itself is so significant is that when the 999 call was made at 6:09 a.m. on the morning of the tragedies, the entire farmhouse, White House Farm, was surrounded by armed police, and Jeremy himself had been in the company of police officers outside the farm, in the grounds surrounding the property, for over 2 hours. And so if that call was made, it cannot have been Jeremy. And you think, well, friends have said to me, so what? There was a 999 call. So what? When police broke in, everybody was found to be dead with near instantly fatal or instantly fatal headshots. There you go. The 999 call makes no difference. No, no, no. The fact that the people found dead in the house, including Jeremy's adoptive sister, Sheila Bamber, all had near instantly fatal or instantly fatal headshots. And the fact that Jeremy is known to have travelled to White House Farm from his cottage in Goldhanger, 3 miles away, at around about 3:30 or thereabouts, proves that it couldn't have been him. that made the call. Now, breaking it down, if you put those factors together, how is it that somebody who suffered a fatal headshot right through the brain, Jeremy's adoptive sister Sheila, is then capable 3.5 hours later of picking up the phone within the property and dialing 999? It's, to my mind, physically impossible. So what must have happened is Jeremy is innocent and Sheila was the killer. At 6:09, she picked up the phone and dialed 999, we believe, without saying anything, and then left the line open, off the hook, if you like. As police started to break in, she then took the rifle and ended her own life. And that was the initial police conclusion, that she'd committed suicide after murdering the family. But for reasons that the police have still not been able to credibly elucidate, they moved away from that proposition and went after Jeremy instead. Now, in respect of the actual 999 call itself, groundbreaking evidence emerged in the last 12 months from the now late PC Nicholas Milbank, who told the New Yorker magazine in an audio interview that he was the one who took the 999 call from White House Farm. In fairness, he also said, well, it was a long time ago and I can't remember much about it, to be honest. And the statement he gave to the New Yorker wasn't in clinical conditions, it wasn't under oath, etc., etc., etc. However, notwithstanding all of that, he gave the game away that this was definitely a 999 call, and his words are to be 100% believed, and this is why. In that interview, he said that he knew the location, White House Farm. From my experience in the 1980s, I remember that the only way to ascertain the location of an incoming 999 call is if it's traced. Now, if nobody spoke on the line, that, in the eyes of BT, is an unresolved issue, an unresolved call. And in all such cases, unless the operator is obviously certain that somebody has misdialed and they checked with the caller to check that it was a mistake, they would then go through to the police and they would say, well, I'm not quite sure about this call. I think it should be traced. The police would then give the go-ahead for the call to be traced. In other words, the location, phone number and address to be ascertained by BT while the line is held and then passed to the police. Now, Nicholas Milbank did not say this in his interview, but numerous times in the interview, he confirmed that it was White House Farm where the call came from. And this is my concluding point. It is impossible for Nicholas Milbank or British Telecom to be aware of the location unless the call was traced. And why would it be traced? Because British Telecom told the police that they, British Telecom, had had an incoming emergency 999 call requiring a trace. Now, when you put all those factors together, there is simply no way that it couldn't have been a 999 call. And I think, therefore, the evidence that the now late Nicholas Milbank gave, in effect, conclusively proves that he was right and that his testimony is absolutely reliable and should be taken seriously by the Court of Appeal, that there was a 999 call, because he himself is aware of the tracing procedure that I myself, having worked for British Telecom in the 1980s, is also aware of. Now, that takes us to the point where the 999 call itself, the actual fact of the 999 call itself having been made, is beyond dispute. There's one other thing to add to this. The police have said in various statements over the years, over the decades, in fact, oh, well, no, there wasn't a 999 call. What happened is one of our officers dialed the conventional 100 operator, and the 100 operator asked us to listen to the line that was off the hook. Much like you would call the operator and say, sorry, this number is engaged. Can you check if the line is off the hook or whether it's engaged in conversation? And according to the police, they were connected by the BT operator at around about 10 to 6 to enable them to listen to the line. Now, just before the 2002 appeal, Jeremy's lawyers uncovered a document which asserted that a 999 call had been made. Interesting stuff. Jeremy's lawyer then started to investigate. And the police came up with a typed statement, which Nicholas Milbank himself subsequently denied making. And it contains this phrase: if contact had been via the telephone, it would have been into the open line and not another dialed call. In other words, what they're trying to say is that there couldn't have been a 999 call, so all the reports of a 999 call having been made can just be disregarded. Well, no, I'm afraid not. That's nonsense. And the reason is this: nothing would have prevented Sheila Bamber from replacing the receiver. Whereupon the 100 operator, and I know this from personal experience, the 100 operator would have disconnected the line because there was no longer anything for the police themselves to listen to. And that's well-established procedure. You can't, as a BT exchange, clog up somebody's line without any obvious reason. I mean, irony of ironies, what if they want to pick up the phone and call the emergency services, call the fire brigade or the ambulance or the police? And of course, in those days, before the days of mobile phones, somebody's landline was literally their lifeline, and especially White House Farm, which is a property surrounded in its own grounds with no immediate neighbours nearby. So the line would have been released. Therefore, this is all a red herring, this explanation, because the line would have been released by BT after the receiver had been replaced, whereupon Sheila Bamber, who we believe made the 609-999 call, could have picked up the phone again and dialed 999. So the people who drafted this statement on Nicholas Milbank's behalf didn't really do their research. And I think it's a faked document myself, because they're saying things that couldn't possibly be applicable in the world of the BT telephone exchange. The line would have been released, and therefore, even if police were listening to the open line from around about 10 to 6 onwards, that still wouldn't have stopped a 999 call from having been made. Now, the concluding point is this: Essex Police is now in a situation where it has no defence whatsoever to the claims, the credible claims of a 999 call having been made. And I believe that this is the piece of evidence that will eventually, for all the reasons I've described, result in Jeremy's conviction being quashed.
So I think that's really interesting, hearing that from Michael and where that is with the CCRC. So what was the next piece that you wanted to share with us?
Well, the other thing I'll go on to was something that actually wasn't involved in the New York article, but again involves another phone call. When the initial documentation was released to the defence before the trial, there was just one record of a phone call to police earlier in the morning at 3:26, alerting them to the unfolding sort of drama at White House Farm. And at trial, the prosecution said that this was when Jeremy phoned the police to tell them that his father, Neville, had phoned him, Jeremy, at about 3:15 in the morning to say that Sheila had got hold of one of the guns and would he come round to help calm her down and diffuse the situation. When Jeremy couldn't get hold of his father when he rung him back, he became increasingly concerned and did eventually call Essex police to ask for their assistance. And that's what prompted the firearms response that followed. However, it then emerged many years later, after a big disclosure of hundreds of thousands of documents in about 2010, that there was another log recalling a call at 3:36, which had explicitly Jeremy's name on it. Now, that clearly was the call that Jeremy made to the police, and everybody accepts that he did call the police, that what was in dispute at the time. And looking at the original document that had been disclosed, it said, "My daughter has got a gun and gone berserk." And it recorded the name of Neville Bamber at the address of White House Farm. And when both logs were available to the defence, they realised that in fact there had been 2 calls to police that morning. And the prosecution and Essex police had hidden the fact that there had been a call from Neville Bamber. Now, because of the logistics involved, if Neville Bamber made that call, there is no way Jeremy could have been guilty, because Essex police accepted that he had called them from his home in Goldhanger, which was about 3 miles away from White House Farm. So there wouldn't have been enough time for him to have made both phone calls, etc., etc. And that is why Essex police have hidden the original call. So this is another major aspect of the case that we've asked CCRC to concentrate on. Again, so far they'd have dismissed it on pretty spurious grounds, but we've gone back to them on that point and said, you really do need to reconsider this. So that is the second major point that we feel not just makes the conviction unsafe, actually proves that Jeremy is innocent. It goes beyond just raising the question mark over the conviction. It shows that it's completely flawed. So that is the second major item. Going back to the New Yorker investigation, the third element that they raised was about interference with the crime scene. Now, we know that there was significant from people who were there and people who subsequently saw the video recording that was made of the scene earlier than the crime scene photos were taken. That video has never been disclosed, and we assume it's been destroyed because it would have seriously undermined the police's narrative. And there was when the police, because they they knew that it was a murder-suicide because they'd been talking to Sheila earlier in the evening. And they had about 6 or 7 reasons why they were quite certain it was a murder-suicide. They didn't feel they needed to do the usual scenes of crime procedures that they would have done if there'd been a question mark over what had happened. So they moved things around, but then realized, oh, we'd better take some badgehead to this scene, and had to put a lot of things back to where they thought they originally were in order to, recreate the scene. But what emerged from Heidi Blake is that one of the scene's crimes officers confirmed that there had been a huge amount of rearranging of the scene. Now, people might think, well, that's not the end of the world. But it is when huge conclusions have been drawn from the crime scene photos. And one of the elements that was applied to is the Bible, the blood-stained Bible that was lying next to Sheila in the crime scene photos. In those photos, it was lying right up against her right shoulder, which you can see is a very unnatural position for it to have been in if she had been reading it and then put it down before taking her own life. And in the 2002 appeal, that the Court of Appeal made huge play at this, that this was strong evidence of Jeremy's guilt, because it implied that a third party had recreated this scene by putting the Bible in that unnatural position, and therefore somebody else had done that. And the obvious implication was that somebody else was Jeremy. But in her interview with the scenes of crime officer, Neil Davidson, Davidson just said, "Oh, well, my boss, who was the head of the scenes of crime activity, Ron Cook, picked up the Bible from where it had originally been, had a flick through it, and then thought, oh my God, I better put this back, and probably put it back in a completely different place." Because we have a number of statements from the original firearms team who said that in the crime scene photos, the Bible was nowhere near where it was when they saw it. So that was a huge change in the way that the jury would have interpreted the evidence they were given. And again, there are other elements of the change that were seen, but that was one that particularly stuck out. So that was the second thing that the New Yorker investigation came up with. And the final major item is that the prosecution case relied on really two pieces of forensic evidence. Some blood that was found in a moderator, a silencer for the rifle that was used, that was found by the relatives who eventually became the beneficiaries 3 days after the police had searched the house. And the blood was just inside the top of this moderator. And that blood supposedly matched Sheila's blood grouping. And the prosecution case at trial was, if the moderator had been fitted to the rifle, Sheila would not have been able to put it under her chin to commit suicide because her arms weren't long enough to reach the trigger with the moderator on. Therefore, again, a third party that had been responsible for that. Now, the second thing on the moderator was some paint on the end of it. And that supposedly had come about in a fight between Jeremy and his father in the kitchen, where the moderator had struck the underside of the round, which went round the Arpa in the kitchen. So those were the two pieces of key forensic evidence the prosecution presented.
One of the other parts of this case, which has very seriously bothered me, is the release of two phone logs, one from a call made by Jeremy at 3:36 to PC West, reporting to PC West that his father had just telephoned him to say, please come over, Sheila has gone crazy with the gun, and another log, and this is the key log, a log timed 10 minutes earlier at 3:26, which nobody looking at that log on its face would disagree represents evidence, police evidence of a call from Neville Bamber himself to the police. Now, over the years, the police have tried to say in a roundabout way that both of these logs would relate to the same phone call and somehow the timings were confused. I mean, for many reasons I won't go into here, I don't buy that at all. But the principal reason is that the material differences between the logs are so great. And remember, the police version of events is that the first log came about as a result of what Jeremy told police, and the second log came about as the result of what that police officer told a civilian radio operator within Essex Police Headquarters. Now, why would that police officer at the outset of an incident totally change what he was reporting to headquarters? It just doesn't make sense. And remember, in those days, especially in the 1980s, before the police had their body cameras and recording devices and such like, that a policeman's notebook, what they noted on a police log, had to be absolutely accurate. So this 3:26 log of a call from Neville Bamber to police is an accurate record for that very reason. There's another reason why these logs, I believe, will eventually, along with the 999 call, result in Jeremy's acquittal, and it's this. The officer who testified at trial, who said he took a call from Jeremy Bamber, said, well, initially I didn't know what to do. I didn't know which local station to get in touch with because I'd never heard of Tolson Darcy. And so what I had to do is I had to spend several minutes telephoning headquarters to ascertain that Witham Police Station was the police station that I, the officer concerned, should then contact. Okay, fair enough. How is it, therefore, that the other log of Jeremy's call to the police records, and this was confirmed in the trial evidence, records that somehow this same police officer was able to contact Witham Police Station within a minute of Jeremy giving the basic details to police? He must have known that it was Witham Police Station he needed to contact. Otherwise, he wouldn't have been able to call them straight away. So now we have two versions of the same thing. Number one, from the same officer. Number one, I knew exactly what station to contact and I telephoned them straight away. And I had no idea which station to contact, so I had to waste 4 or 5 minutes finding out which station I needed to get in touch with. Now, those are fundamentally incompatible with one another. The only explanation is that the officer concerned took both phone calls, and he knows he did, I assert. At 3:26, from Neville Bamber to the police. Now, at 3:26, from Neville Bamber to the police, that's the first call, and PC West at that time didn't know which station covered the village concerned, which was Tolson Darcy. And then a couple of minutes later at 3:30, he contacted Witham. When it comes to the 3:36 call from Jeremy Bamber to the police, somehow the same police officer is able to instantly call Witham Station the moment he's been able to record the basic details from Jeremy himself. And therefore the only explanation by reference to the trial evidence itself is that there was two separate calls. And it personally frustrates the hell out of me that nobody has come along and worked this out and figured out that on that basis alone, it's a miscarriage of justice, because that's the only explanation that fits.
Now, we know we had a report done in 2012 from 3 very eminent US pathologists who all said that no moderator was used in the shooting of Sheila. They analysed the crime scene pictures of her wounds, and they were absolutely categorical that they were typical of a shot without a moderator. And we've now had a further report done by a leading UK expert saying the same. And also in the forthcoming Channel 5 programme, people will see a recreated experiment by a leading firearms expert called Phillip Walker that quite clearly shows the difference between wounds with and without a moderator. And it's very apparent that Sheila was shot without a moderator. And if she was shot without a moderator, all of the evidence that relates to that device clearly falls away. So those two pieces of key forensic evidence, the blood and the paint, just are removed from the case. And if they are removed, then there is literally no case against Jeremy. And all of those things together, we believe, prove Jeremy's innocence, not just question it.
So, what's really important about this, I mean, obviously it's critical that after 41 years in prison, which is just unimaginable, that Jeremy gets some kind of fair hearing. But it brings up, the importance of this beyond just Jeremy is, you have a jury and you're expecting a jury to make a decision. But in order for them to make any kind of decision, they have to have all the pieces. And what we're learning is that they don't necessarily get all the pieces. So, it's like you spend hours making a jigsaw puzzle only to discover that, several key pieces mean you can't really see the whole picture. And so this kind of makes a mockery of a justice system, because you have all these people, just an umbrella, the police, and anyone else that's putting the case together, they do this day in, day out. They're used to, and they know how to construct things to win arguments. But if you're in Jeremy's position or someone else, you're only ever going through this once in your life. So how do you know? And you're just relying on a legal team who also may be deprived of some of the necessary information. And it just seems to me that, how do we get past this? That's the importance of why the public needs to be, as indeed you're, a member of the public, we need to be taking care of this, because this could be someone this could be, no one knows when they're going to find themselves in these positions.
Yeah, that's absolutely right. And that was probably the main thing that really shocked me when I first got involved in the case. As an ordinary member of the public previously, I thought that, well, when you go to trial, all of the evidence on both sides is presented and the jury gets to make an informed decision on all of the facts. But in fact, that is not what happens at all. The jury get to see basically what the police want, the police and the prosecution. And they have wide discretion to decide what is relevant to a case. Now, the other thing about the moderators is that we know there was more than one moderator. And in fact, these two key pieces of forensic evidence, the blood and the paint, were on different devices. And the police conflated the two results and presented them as having come from one device. And in fact, that was the last thing that the New Yorker investigation came up with, when one of the revisits confirmed that the police had taken away several of his moderators well before the trial, and therefore were in possession of multiple moderators before the trial, which is something they had vehemently denied for 40 years. So they had been caught out in that particular lie. But going back to what the jury see, the jury were never told there was more than one moderator. They were never told that there was a phone call from Neville Bamber also on that morning to warn the police. They never knew that there was a 999 call from inside the house at 6:09. And of course, once you are convicted, evidence flips 180 degrees, because you then have to prove that you're innocent. And how do you prove something when you can't get hold of all the exonerating evidence? So the whole thing is deeply flawed. In America, they have what's called a Brady violation, which is a ruling whereby if any material is withheld from a trial, then it automatically becomes a mistrial. And that removes the incentive for either the police or the prosecution not to be completely candid in what they present at trial. But here, it's a totally different situation. The police choose what they show. In most cases, I'm sure they do that honestly and, fulfill their moral obligation. But there is always the temptation, if you think somebody's guilty, to just, oh, well, we won't bother with that bit of evidence because it's not particularly relevant. And, in a very few cases, such as Jeremy's, that goes into real overdrive, and they hide really key pieces of exonerating evidence, such as the ones we touched on earlier. So hopefully, if as and when Jeremy is exonerated, one of the changes that will follow is a huge tightening up of the disclosure regime, where we won't find ourselves in this situation again, that any trial that happens does have access to all of the information in order that a jury can make an informed decision.
And it's interesting because as you were talking, I think when you sit on a jury in a case, I think you're sort of sworn to secrecy, aren't you? Mm-hmm. I'm thinking about those jury members. I mean, I don't know who they are, but I'm thinking about if I'd sat on that jury and I'm now 41 years later and I'm now facing the idea that I convicted someone, I said they're guilty based on what was given to me, in all fairness, and no, I'm not sort of casting any aspersions on any jury member, but I'd feel terrible. I'd feel so cheated and kind of almost victimised myself, because who wants to be part of putting somebody away in jail that didn't do it. So the repercussions go on and on.
Yes, they do. Yeah, I mean, if I found myself in that situation, I would feel that I've been hugely manipulated and sort of, in a way abused. My judgment had been abused because I wasn't told what had actually happened. I was given a distorted picture that was skewed in one particular direction. And don't forget, even with all that skewing in the prosecution's favour, two of the jurors found him not guilty. So it was not a unanimous verdict. So even, some of the jury clearly had that even on the biased picture they were shown.
That's an interesting thing. I don't know that we're allowed to go and talk to the jury or that, those jury members, but I mean, I don't know how it works, but it's an interesting thing, isn't it, to be able to, it would be an interesting proposition to find some of those jury members and talk to them.
Well, I mean, we as a campaign obviously can't do that quite rightly. I think, it would not be appropriate for jurors to be approached in that way. Although one of the jurors was spoken to, and quoted in Caroline Lee's book, and he said basically we found him guilty because the judge told us. And that's the other element that really played a massive part in his conviction. But the judge, Justice Morris Drake, for whatever reason, clearly decided that Jeremy was guilty, and he was going to do everything in his power to make sure that the jury arrived at the correct verdict. And his summing up was just a masterpiece of basically telling them, go away and do your duty and find him guilty.
Yes, I've seen that in some cases where a judge definitely directs the jury. Definitely.
Because the jury came back and asked a question about the blood evidence, which was absolutely central to their deliberations. And although we now know that because there was no moderated blood evidence was irrelevant at the time, that wasn't that. And they asked the judge whether this blood that had been found inside moderator was Sheila's and Sheila's alone. And the judge replied, yes, it is. And it's really that got them over the line. And we now know that Drake was well aware that because it was blood grouping, which is not the same as DNA, where you can identify an individual from testing, you can only identify a group of people who may have this particular blood type. He was well aware that other people, including some of the relatives who had handled the moderator, had the same blood group, as well as 8% of the UK population. But the jury were told none of that. But they said, can we be certain that it was Sheila's blood? And he told them, yes, you can. And within 21 minutes, they came back with the guilty verdict.
Wow. So I think at this point, we're coming to the end of our time together. I think that there's some final things from Michael that's worth us hearing. So we'll just listen to that.
A call from the father at 3:26 to police saying, my daughter Sheila has gone mad, followed 10 minutes later by a call from Jeremy to the police saying, you've got to go to White House Farm, Tolson Darcy, because my father has just called me in a distressed state and he obviously needs help. I can think of no other reasonable or plausible explanation. And put in those terms, I believe that the Court of Appeal, I'm no lawyer, but I believe the Court of Appeal will find it very hard to reject such an argument. That is, if the CCRC itself can actually get off its behind and do the job that it was set up to do, which is to investigate and refer potential miscarriages of justice.
Yeah, so thank you for coming on All Things Conflict and talking us through this. It's exceptional voluntary piece of work that you're doing that has, far-reaching consequences beyond Jeremy. It's going to be very interesting to see how this plays out, and shameful that these things take so long.
Yes, it is. That's one of the really scary things about this. As I mentioned, our latest submissions, and these are Jeremy's third submissions to the CCRC, taken 5 years already, and they haven't even looked at half of the issues. And the other point I'd just say that, I am part of a much larger team. There are a lot of people working on this on Jeremy's behalf. I just happen to be the one that's come along to talk to you today, but there are a lot of other people doing a lot of hard work on this, and a lot of legal people helping out as well, pro bono. So this is a big collective effort, and we hope that very soon we'll reach a successful completion.
Thank you. And I do wish you every success with everything that's moving forward, and do keep me informed and in touch.
We certainly will. We certainly will.
Thank you.